I spent 15 years as a civil rights attorney in Texas, believing that the American justice system, while imperfect, was fundamentally designed to protect the innocent and hold the guilty accountable. I fought cases in courtrooms across the state, won victories for clients who had been wronged, and genuinely believed that justice was something we could achieve if we just worked hard enough and fought smart enough. But after 18 months in Congress, after seeing how the justice system really operates from the inside, after witnessing firsthand how laws get written and enforced, I can tell you that everything I thought I knew about justice in America was wrong. What I learned about justice will shock you because it shocked me, and I thought I had seen it all. The first crack in my understanding came during a routine oversight hearing about federal sentencing guidelines. I was reviewing cases where similar crimes had received wildly different sentences, and I expected to find the usual disparities that we know exist in the system. Rich defendants getting better outcomes than poor defendants, white defendants getting lighter sentences than black defendants, connected defendants getting deals that ordinary people never see. But what I found was something far more systematic and far more disturbing than individual bias or unequal representation. I discovered that the American justice system isn't just biased or unfair in the ways that civil rights lawyers have been documenting for decades. The system is deliberately designed to produce different outcomes for different classes of people. It's not a bug in the system, it's a feature. The disparities aren't accidents or the result of unconscious bias. They're the intended result of laws, policies, and procedures that were created specifically to ensure that justice serves some people while controlling others. The drug war provides the clearest example of how this works. For decades, we've been told that drug laws exist to protect communities from the harmful effects of illegal substances. But when I examined the actual implementation of these laws, I found something completely different. The same drugs are policed, prosecuted, and sentenced differently depending on who's using them and where they're being used. Cocaine and crack cocaine are chemically almost identical, but crack cocaine, which is associated with black communities, carries sentences that are 18 times longer than powder cocaine, which is associated with white communities. This isn't an accident or an oversight. Congress knew exactly what they were doing when they created these sentencing disparities. They were creating a system that would incarcerate black people at much higher rates than white people for essentially the same behavior. But the drug war disparities go far deeper than just cocaine sentencing. Marijuana, which is now legal in many states, was criminalized specifically to target black and brown communities. The federal officials who created marijuana prohibition explicitly stated that their goal was to control and criminalize communities of color. They succeeded beyond their wildest dreams, destroying millions of lives and families for behavior that we now acknowledge should never have been criminalized in the first place. The opioid crisis reveals how justice works when it affects white communities instead of black and brown communities. When crack cocaine devastated black neighborhoods in the 1980s and 1990s, the response was mass incarceration, militarized policing, and harsh mandatory minimum sentences. When opioid addiction affected white suburban communities, suddenly addiction became a medical problem requiring treatment and compassion rather than a criminal problem requiring punishment. The same behavior, drug addiction, was treated as a moral failing deserving imprisonment when it happened in black communities and as a medical condition deserving treatment when it happened in white communities. The difference wasn't the drugs or the addiction or the behavior. The difference was the race and class of the people involved. But drug policy is just one example of how the justice system was designed to produce different outcomes for different people. The entire structure of criminal law enforcement, from policing strategies to prosecutorial decisions to judicial sentencing, operates according to principles that have nothing to do with equal justice under law and everything to do with maintaining social and economic hierarchies. Policing in America isn't really about fighting crime or protecting public safety, though that's how it's sold to the public. Modern policing is about social control, revenue generation, and maintaining the racial and economic hierarchies that benefit wealthy white communities at the expense of everyone else. Police departments function as occupying armies in black and brown communities while serving as protectors and servants in wealthy white communities. I've reviewed police deployment data from cities across America, and the pattern is consistent everywhere. Police spend the majority of their time in communities of color, not because those communities have higher crime rates, but because those communities have less political power to resist aggressive policing. Meanwhile, white-collar crimes that cause far more economic damage and affect far more people receive minimal police attention because the perpetrators have the political and economic power to avoid scrutiny. The war on drugs created a massive pipeline from black and brown communities directly into the prison system, but it was never really about drugs. It was about creating a legal framework for the mass incarceration of people who were becoming politically and economically powerful in ways that threatened existing hierarchies. The civil rights movement had made explicit racial discrimination illegal, so new forms of social control had to be created that could achieve the same results while appearing racially neutral. Mass incarceration became the new Jim Crow, serving the same function as the old system system of racial control, but using criminal justice instead of explicit racial categories. Once someone has a felony conviction, they can be legally discriminated against in employment, housing, education, and voting. They can be excluded from jury service, denied public benefits, and subjected to ongoing surveillance and control. It's a system of social control that's more comprehensive and more effective than anything that existed during the era of legal segregation. The prison industry that grew up around mass incarceration created powerful financial incentives for maintaining high incarceration rates, regardless of crime rates or public safety needs. Private prison companies, which profit directly from keeping people incarcerated, have become major players in criminal justice policy making. They lobby for longer sentences, oppose rehabilitation programs, and fight against any reforms that might reduce their profits. But the corruption goes far beyond private prisons. The entire criminal justice system has become a profit center that generates revenue for governments, corporations, and individuals who have financial interests in maintaining high incarceration rates. Bail bondsmen, court systems, probation companies, electronic monitoring firms, and dozens of other businesses profit from keeping people trapped in the system. Plea bargaining, which now resolves over 95% of criminal cases, has eliminated the constitutional right to trial for most defendants. Prosecutors can threaten defendants with sentences so harsh that even innocent people feel compelled to plead guilty rather than risk conviction at trial. This system allows prosecutors to secure convictions without having to prove guilt beyond a reasonable doubt, while creating the illusion that the system is processing cases efficiently and fairly. The plea bargaining system is particularly devastating for poor defendants who can't afford competent legal representation. Public defenders, who represent the majority of criminal defendants, are so overloaded with cases that they often spend less than an hour preparing for each case. Defendants who can afford private attorneys get justice. Defendants who can't afford lawyers get processed through a system that prioritizes speed and efficiency over accuracy and fairness. But what really opened my eyes to how the justice system actually operates was learning about prosecutorial immunity and qualified immunity, legal doctrines that protect law enforcement and prosecutors from accountability even when they violate constitutional rights or break the law. These immunities mean that prosecutors can fabricate evidence, hide exculpatory information, and secure wrongful convictions without facing any personal consequences. Police can use excessive force, conduct illegal searches, and violate civil rights without being held personally liable for their actions. The Supreme Court created these immunity doctrines not because the Constitution requires them, but because they wanted to protect government officials from accountability. The result is a system where the people with the most power to affect others' lives face the least accountability for their actions. Citizens who are victimized by prosecutorial misconduct or police brutality have almost no recourse against the officials who harm them. Federal civil rights laws that were passed during Reconstruction to protect formerly enslaved people from state and local government abuse have been systematically weakened by Supreme Court decisions that make it almost impossible to hold government officials accountable for constitutional violations. The same legal system that was supposedly created to ensure equal protection under law has been restructured to provide maximum protection for government officials and minimum protection for citizens. The death penalty reveals the justice system's bias in its most extreme form. Capital punishment is almost exclusively applied to defendants who kill white victims, particularly white women. Defendants who kill Black victims are far less likely to receive death sentences, regardless of the circumstances of the crime. This disparity exists because the justice system treats some lives as more valuable than others, and it uses the ultimate punishment to reinforce those value judgments. But the bias goes beyond just victim race. Defendants who are represented by competent attorneys almost never receive death sentences, while defendants who are represented by overworked or incompetent public defenders are much more likely to be sentenced to death. The quality of legal representation, which is directly tied to wealth and class, becomes the determining factor in who lives and who dies. I've reviewed cases where defendants were sentenced to death despite having intellectual disabilities, mental illness, or histories of severe childhood trauma that should have precluded capital punishment. I've seen cases where prosecutors withheld evidence of innocence, where defense attorneys slept through trials, where judges were later found to be corrupt or incompetent. The death penalty system is so flawed and so biased that it's impossible to have confidence that we're executing only the guilty or that we're applying capital punishment fairly across racial and class lines. The wrongful conviction rate in death penalty cases is staggering. Since 1973, over 190 people on death row have been exonerated and released, meaning that for every 9 executions, one person on death row has been found innocent. These aren't just technical legal victories or cases where guilty people got off on technicalities. These are cases where DNA evidence, prosecutorial misconduct investigations, or other evidence prove that the convicted person was completely innocent of the crime. If we know that the system wrongfully convicts innocent people at such high rates in capital cases, where the stakes are highest and the scrutiny is most intense. What does that tell us about the accuracy of convictions in less serious cases where there's less oversight and less resources devoted to ensuring accuracy? The answer is that wrongful convictions are endemic throughout the system, but we only discover them in a tiny fraction of cases because most defendants don't have access to the resources needed to prove their innocence. The forensic science that's used to convict people in criminal cases is often far less reliable than juries are led to believe. Hair analysis, bite mark comparison, fingerprint analysis, and other forensic techniques that were once considered infallible have been shown to be much more subjective and error-prone than claimed. Hundreds of convictions have been overturned when DNA evidence contradicted other forensic evidence that was used to secure the original conviction. But even DNA evidence isn't foolproof, and the crime labs that process forensic evidence are plagued by contamination, incompetence, and misconduct. Some crime lab analysts have fabricated test results, while others have been so incompetent that their work has called thousands of convictions into question. The pressure to help prosecutors secure convictions creates incentives for forensic analysts to reach conclusions that support the prosecution's case rather than to provide objective scientific analysis. Eyewitness identification, which the public considers highly reliable, is actually one of the least reliable forms of evidence. Cross-racial identification is particularly unreliable, with white witnesses making frequent errors when identifying black suspects. But the criminal justice system continues to rely heavily on eyewitness testimony despite decades of research showing its unreliability, because admitting that eyewitness identification is unreliable would call thousands of convictions into question. The confession evidence that prosecutors use to secure convictions is often obtained through coercion, deception, and psychological manipulation that would be illegal in other contexts. Police are allowed to lie to suspects, to threaten them with harsh sentences if they don't confess, and to interrogate them for hours without breaks. These techniques produce false confessions from innocent people, particularly juveniles and people with mental disabilities who are more vulnerable to coercive interrogation tactics. But perhaps the most shocking thing I learned about the justice system is how it treats sexual assault and domestic violence. Despite decades of advocacy and reform efforts, the system still systematically fails survivors of gender-based violence while protecting perpetrators, particularly when those perpetrators are wealthy, white, or politically connected. Sexual assault cases have conviction rates far lower than other violent crimes, not because sexual assault is harder to prove, but because the system is designed to protect accused men rather than to seek justice for women who have been victimized. Survivors who report sexual assault are subjected to interrogation techniques designed to discredit their testimony, while defendants benefit from legal strategies that put the survivor's behavior and credibility on trial rather than focusing on the defendant's actions. The justice system's treatment of domestic violence reveals similar biases. Domestic violence is consistently under-prosecuted and under-punished, with perpetrators often receiving light sentences even for repeated offenses. Meanwhile, women who defend themselves against abusive partners are often prosecuted more harshly than the men who abuse them. The system that claims to protect the innocent systematically criminalizes survival while tolerating abuse. Reproductive rights provide another window into how the justice system serves some people while controlling others. Laws restricting abortion access are designed to control women's bodies and women's choices, while men face no similar restrictions on their reproductive autonomy. The criminalization of abortion creates a system where women can be prosecuted for making healthcare decisions, while the men who impregnated them face no legal consequences. The justice system's treatment of LGBTQ+ people reveals additional layers of bias and discrimination. Despite legal progress in some areas, LGBTQ+ people, particularly transgender people and LGBTQ+ people of color, face discrimination and violence throughout the criminal justice system. They are more likely to be arrested, more likely to be convicted, more likely to receive harsh sentences, and more likely to face abuse while incarcerated. Immigration enforcement has become another tool for social control that operates outside normal constitutional protections. Immigration courts, which are not really courts at all, but administrative proceedings, deny defendants basic due process rights, including the right to legal representation. People can be detained indefinitely, separated from their families, and deported for minor offenses or technical violations that would result in minimal punishment for citizens. The immigration system is designed to create a vulnerable workforce that can be exploited by employers without fear of legal consequences. Workers who are undocumented can't report labor violations, workplace safety problems, or wage theft because they risk deportation if they interact with with government agencies. This vulnerability serves the interests of employers who want cheap, exploitable labor while harming both undocumented workers and citizen workers whose wages and working conditions are undermined by the existence of a fearful, exploitable workforce. Juvenile justice reveals how the system fails children and families, particularly in communities of color. Children as young as 13 are prosecuted as adults for offenses that would be handled through counseling and rehabilitation in white suburban communities. The school-to-prison pipeline pushes children out of educational settings and into the juvenile justice system for behaviors that should be addressed through educational support and mental health services. Zero-tolerance policies in schools criminalize typical childhood and adolescent behavior when it occurs in schools serving students of color, while similar behavior in affluent schools is handled through counseling, tutoring, or other supportive interventions. The result is that children from poor communities and communities of color are introduced to the criminal justice system at early ages for behaviors that never result in criminal justice involvement for children from privileged communities. Mental health crises have been criminalized rather than treated as medical issues, with police serving as first responders to mental health emergencies despite having no training in mental health treatment. People experiencing mental health crises are often arrested and incarcerated rather than receiving appropriate medical care, and they face discrimination throughout the criminal justice process because of their mental health status. The justice system's response to addiction reveals similar problems. Instead of treating addiction as a medical condition requiring healthcare intervention, the system criminalizes addiction and punishes people for having a disease. This approach is not only cruel and ineffective, it's also much more expensive than providing treatment and support services that actually help people recover from addiction. Homelessness has been effectively criminalized through laws that make it illegal to sleep, sit, or exist in public spaces. People who are homeless are arrested for behaviors that are necessary for survival, creating a cycle where homelessness leads to criminal records, which make it even harder to obtain housing and employment. The criminalization of homelessness serves to hide poverty rather than address it, while generating revenue for the criminal justice system through fines and fees. Environmental justice reveals how the legal system allows corporations to pollute communities of color while protecting affluent white communities from environmental hazards. Environmental laws are enforced more strictly in wealthy communities than in poor communities, and penalties for environmental violations are often so low that they become a cost of doing business rather than a deterrent to pollution. Corporate crime, which causes far more economic damage and affects far more people than street crime, is handled through civil rather than criminal proceedings. Corporate executives who steal billions of dollars through fraud schemes face civil penalties and regulatory sanctions, while people who steal hundreds of dollars face years in prison. The message is clear: the justice system protects property and punishes poverty, regardless of the scale of harm or the culpability of the actors involved. White-collar defendants benefit from a parallel justice system that operates according to different rules and different standards than the system that processes poor defendants and defendants of color. They are investigated by different agencies, prosecuted by different prosecutors, sentenced by different standards, and incarcerated in different facilities. Even when they are convicted of serious crimes, they face sentences that are a fraction of what poor defendants would receive for far less serious offenses. Tax evasion by wealthy individuals and corporations is handled primarily through civil proceedings that result in financial penalties rather than incarceration, while poor people who make errors on tax returns or fail to file returns face criminal prosecution and prison sentences. The same behavior is treated as a technical violation requiring financial penalties when committed by the wealthy, and as a serious crime requiring imprisonment when committed by the poor. Financial crimes that devastate working families and entire communities are prosecuted as regulatory violations rather than crimes against persons, while survival crimes committed by poor people are prosecuted as serious felonies. The banker who forecloses on a home through fraudulent documents faces civil penalties, while the homeless person who sleeps in that empty home faces criminal prosecution. The entire concept of crime has been defined to protect the interests of wealthy and powerful people while criminalizing the survival strategies of poor and marginalized people. Wage theft, which involves employers stealing money directly from workers, is handled through civil proceedings and results in minimal penalties. Meanwhile, shoplifting, which involves taking property worth far less money, is prosecuted as a criminal offense that can result in years of imprisonment. Healthcare fraud by medical providers and insurance companies, which costs billions of dollars annually and directly harms patients, is prosecuted as white-collar crime with minimal penalties. Meanwhile, people who use drugs to self-medicate untreated medical conditions are prosecuted as criminals and face harsh mandatory minimum sentences. The justice system that I thought was designed to protect the innocent and hold the guilty accountable is actually designed to protect wealth and power while controlling and criminalizing poverty and marginalization. It's a system that serves the interests of those who designed it while claiming to serve the interests of justice and equality. What I learned about justice will shock you because it reveals that the American justice system is not a system of justice at all. It's a system of social control that uses the language and symbols of justice to legitimize inequality and oppression. It's a system that protects the people who least need protection while targeting the people who most need protection. The reforms that have been proposed to address these problems, while well-intentioned, are insufficient because they don't address the fundamental design of the system. You can't reform a system that's working exactly as it was designed to work. You can't fix a system whose core purpose is to maintain inequality rather than achieve justice. What we need is not reform, but transformation. We need to admit that the current system serves wealth and power rather than justice and equality. And we need to build something entirely different. We need a system that's actually designed to achieve justice rather than maintain hierarchies. We need a system that treats all people as equally deserving of protection and respect, regardless of their race, class, gender, or other characteristics. But most importantly, we need to understand that achieving justice requires more than changing laws or policies. It requires changing the fundamental power relationships that determine how laws get written, how they get enforced, and who benefits from the legal system. As long as wealthy and powerful people control the system, they will use it to serve their own interests rather than the interests of justice. That's why I'm speaking out about what I learned, even though it challenges comfortable assumptions about American justice, and even though it implicates institutions and individuals that many people respect and trust. Someone has to tell the truth about how the system actually operates rather than how we wish it operated. Someone has to connect the dots and show how individual injustices are part of systematic problems that require systematic solutions. What I learned about justice shocked me because it revealed that everything I had been taught about American law and justice was a comfortable lie designed to legitimize a system that serves inequality rather than justice. But knowing the truth, as uncomfortable as it is, gives us the power to demand something better and to work toward building a system that actually serves the cause of justice rather than the interests of wealth and power.